In this video, I'm going to take a look at cross-examination. Cross-examination is something that you must do if you are involved in the WRC at an employment-related matter or problem or claim, or you may be involved in a criminal proceeding. Now, clearly, if you're involved in a criminal proceeding, it is very, very unlikely that you are going to be cross-examining anybody, because you will be perhaps the defendant or perhaps a witness, but you won't be doing the cross-examination. Somebody else will be doing it. Solicitor or barrister will be doing it. However, in the likes of a WRC hearing, claim for unfair dismissal or discrimination or something of that nature, and if you decide you want to do it yourself, then it's useful to know and understand what cross-examination involves and entails. So direct examination is where I, for example, would be asking my client to give his version of events, his version of the story as to what happened. Cross-examination then is when I examine or ask questions of a witness or witnesses from the other side. So let's say, for the sake of argument, I'm representing an employee. Well, obviously the employer is going to be the person against whom we're going to be making a claim, and it's likely that I'm going to be challenging and questioning the evidence of the employer or the employer's representative who may be giving evidence. For example, a HR representative, or indeed somebody working in the company as a HR person, or perhaps an accountant or somebody. But in terms of cross-examination, it's questioning the evidence of the other side, essentially. So you'll have seen this down through the years in TV, movies, and so on and so forth. Anyway, in this video, I'm going to look at 5 principles of cross-examination. Cross-examination is not rocket science, but there is a few things that you need to be very careful about, and there is 5 principles at least that you should turn your mind to and take into account. Let's have a look at them. Firstly, leading questions. Leading questions are advised and are allowed. A leading question is, when did you stop beating your wife? You took this employee into your office and fired him without warning or reason, isn't that right? You went on a massive drinking bender when you robbed that shop's till, didn't you? Or you made up these working time records only when you received a letter of this claim from the WRC, isn't that the case? In other words, you're putting your version of events, your story, to the other side, and you're expecting them obviously to deny that, but at least you're putting your version of events. It is a leading question. A question that's not a leading question, an open question, is where I might be doing a direct examination of my own client and leading evidence there. So if my client was involved, for example, in a car accident and was perhaps a passenger, I'd be asking questions like, where did the accident occur, when did it occur, who was driving, and so on. In other words, questions beginning with when, who, why, what, where, how are all open questions, but leading questions are, again, when did you stop beating your wife, or you fired this employee, or you harassed and discriminated against this employee, didn't you, because you hate foreigners, or whatever. They are leading questions. So they are advised and allowed in cross-examination, but they're not allowed in direct examination. And direct examination, remember, is excuse me, when you're taking evidence from your own witness. Short is better than long. So a short cross-examination is better than a long one. A good record of the evidence that's given, or of the evidence that is given in direct examination, should have been obtained. So the person that you're going to question, the witness that you're going to cross-examine, you should have listened very, very carefully and made a close record of what they said in direct evidence, in their direct examination by their own solicitor or representative. And then you're going to cross-examine based on that, but you will have a good record, hopefully, of what they actually said in direct evidence. You're looking to trip them up, you're looking to undermine their credibility, you're looking to undermine their version of events. You try to avoid asking a question, however, to which you do not know the answer. This won't always be possible, but you try to avoid it as best you can. Sometimes you will be in a situation where you simply have to ask the question. You may not know the outcome, but you sometimes do have to ask the question. But by and large, as a generality, you try and avoid questions, the answer to which you don't know. Don't bully or accuse the witness. You may be mistaken in your recollection is far better than you're lying through your teeth as usual, because if you bully or accuse a witness in cross-examination, the likelihood is he or she will get a fair degree of sympathy from the decision maker. Put the case. If you or your client have a different contradictory version of events, you must put that to the witness and give him a chance to rebut it. If you don't put the case, then his version of events is accepted or should be accepted by the decision maker. So you must put your case to the witness, the cross-examination, or the witness in cross-examination, and give him or her a chance to rebut it. Know when to stop. If you get an admission that you want, don't go to town on it, as it may prompt an elaboration or explanation or retraction. That's not what you want. There's a famous railroad negligence case. Avoid this mistake. This is a case, I don't know whether it's true or not, I don't know whether it's an urban myth, but it involved a man, an old man, who was a regular, a habitué of a particular rundown part of an American city. He had a drink problem. He drank in an area of the city with well-known other down-and-outs, people who had difficulties with drink and drugs and so on. But on one occasion, this man was struck and killed by a railroad, a train rather, down at the railroad tracks. And as part of the evidence, his son was brought along. The question of negligence then arose. Was the railroad negligent in respect of this man's death, or did he contribute greatly to his own death by being drunk and falling out in front of the train, and it was self-inflicted to a huge extent, huge amount of contributory negligence and so on? The question of negligence arose. The son, who was there and who was the last one to approach his father, was cross-examined, and the railroad solicitor was going, or attorney or lawyer was going very well with his examination. He was asking the son about the father's problems all his life with drink, and where he hung out and where he drank with his mates and so on and so forth. And rather than stopping when he'd established that this man had a problem with drink and establishing that he was in the vicinity on that occasion and was in the vicinity which was a regular spot for them to drink, he pursued it further with the son, because he had seen, or somebody had witnessed, the son leaning down towards the father after he had been struck by the train. And it was thought by the railroad company attorney that the son had leaned down to remove the bottle of whiskey that was suspected to be in the inside pocket of this man who was the victim of this fatal accident. But rather than stopping, having ascertained and established all the facts, the attorney went one question too far, and he said to the son, "What were you doing when you bent over your father?" And he said, "I was telling him I loved him." So, the suspicion was he was removing a bottle of whiskey, but in fact the question produced an answer which found a lot of sympathy, quite frankly, with the jury. So I was telling my dad I loved him. So know when to stop. Anyway, I hope you find this video useful. It's about cross-examination. As I say, my name is Terry Gorry. If you're interested in subscribing to my YouTube channel, I'd be delighted if you would. You'll be notified if you hit the bell icon, then you'll be notified every time I upload a new video, and I upload new videos twice a week, and I deal with all aspects of Irish law and Irish business. Thanks for watching.